which is a Italian flag flying vessel, an oil tanker. They shot and killed two Indian fishermen on board an Indian fishing vessel called Saint Anthony. So after this shooting incident, and if you look at the written submissions of Italy, it was just an incident which happened in the high seas, and it says that the Marines shot them allegedly mistakenly as pirates, not as genuinely fishermen. And after the incident, the Italian oil tanker, they went ahead further, and about 59 nautical miles from the coast of Kerala, the Indian Coast Guard intercepted this ship and asked them, directed them to the coast of to the port of Cochin. So for all of us, most of us discussing this this issue, sitting in Cochin, it is very important. So after the arrival of the Enrica Lexie ship, the Indian police arrested the crew, basically the two Italian Marines, and charged them under Section 302 of the Indian Penal Code. So 302 of Indian Penal Code basically deals with murder. So this was exercised by this jurisdiction was exercised by Indian authorities under the extraterritorial jurisdiction, because the incident, as we all know, that it happened beyond the territorial waters of India. By applying the extraterritorial jurisdiction of the Indian Penal Code, they have the Indian police could arrest them and started the legal proceedings. And the local courts, the proceedings happened before the local courts, and it went up to the Kerala High Court, and Kerala High Court also upheld the jurisdiction of the local courts in Kerala. And further down the line, the case went up to the Supreme Court. The only change the Supreme Court made was, yes, India has jurisdiction over the matter, but it should not be the Kerala High Court or the courts in Kerala that should be trying the Italian Marines. So they've basically ordered for the establishment of a special court in Delhi for the criminal proceedings against these Italian Marines. And as we all know what happened after that, there were a bit of diplomatic tussle, because in the meanwhile, on two occasions, these two officers were allowed by the Indian authorities to go and visit their family in Italy. One was during the Christmas season in 2012, and later in 2013 during the national elections, they were allowed to go to Italy and cast their votes. So after this second return to Italy, there was a note verbale from the Italian government saying that these Marines would not be coming back to India. So from there started the actual standoff between Italy and India on a diplomatic level. And after that, because that time the case was pending before the Supreme Court of India, and then the Supreme Court asked the Italian ambassador to India not to leave the country. And the diplomatic discussions and the standoff worsened after that. But anyway, after a point of time, the Italian government allowed or asked them, returned the Italian Marines to come back to India. And after a few years, 2015, I guess, Italy again Italy actually for the first time moved to an international forum. So if you look at the United Nations Convention for the Law of the Sea, the UNCLOS Convention has 3 or 4 mechanisms for dispute settlement. So they've approached, so these mechanisms are basically the International Tribunal for Law of the Sea, which is based in the Hamburg International Court of Justice, or the arbitral tribunal or arbitration mechanism created under Annex 7 of the UNCLOS, and there is also a special arbitration mechanism under Annex 8 of the UNCLOS. So they've approached, Italian government approached the UNCLOS, the ITLOS for provisional measures, the International Tribunal for Law of the Sea for provisional measures, saying that India has no jurisdiction over this issue, and asking the ITLOS to issue provisional measures to the effect of suspending all the criminal legal proceedings pending before the Indian courts. And ITLOS accepting the claims made by the Italian side, they've asked India to suspend all the proceedings. And as a result of that, it was provisional measures. A new mechanism was established. The case was transferred, or the case was given to the new arbitration tribunal administered by Permanent Court of Arbitration under Annex 7 of the UNCLOS, the United Nations Law of the Sea Conventions. So the UNCLOS Arbitral Tribunal, after a few years of hearing, and there was a change in the arbitrators also, because during the proceedings, one of the arbitrators, the Indian nominee, the Indian appointed arbitrator, P.C. Rao, because of his ill health and his death, a new arbitrator, P.S. Rao, was appointed. Anyway, I think on 21st of May this year, they've concluded the arbitration proceedings and rendered their award. And the award was made available to the public on 2nd of July, which is 2 weeks ago. So this is the basic timeline or the story behind this Enrica Lexie incident. And so as the literature says, and as we can see from the judgment or the award, there are two pertinent issues here. One is the exercise of jurisdiction over this incident, over the Italian Marines, and most importantly, the immunity issue. The question whether these two naval officers on board a ship, a merchant ship, a commercial ship, are entitled to diplomatic immunity under the international law. So these are the fundamental issues that we will be discussing, or the key speakers will be deliberating upon. Before that, I think giving the floor to Deepak and Syam, I think for me, the fundamental issue here is, of course, there are many principles of jurisdiction that we've seen, and very important case laws such as the Lotus case, which from the reading of that case, you can say that yes, in Italy. So one of the reasons why India was claiming jurisdiction was based on the Lotus principle of the effects doctrine and other principle of objectivity, etc., for exercising criminal jurisdiction by Indian side. But here, that's one crucial issue for us. But most importantly, I think here, after the judgment, after the recent award, it sets a precedent saying that even soldiers or marines, armed marines on board private ships or commercial ships are allowed immunity, diplomatic immunity. So here the conflict here is because, as we know, under the International Maritime Organization's efforts to combat piracy, it is a general practice that even merchant ships, they have state officials or soldiers, armed soldiers on board. But there is always a tussle between, or a miscommunication between, because as we all know, the master of the ship or the captain of the ship has no authority over these state officials, or the Marines or the soldiers who are appointed or posted on board the ship. So whatever they do, they have immunity after this, or according to the diplomatic immunity conventions and this particular judgment, whereas they are not under the control of the captain of the ship. So that conflict is a bit intriguing for me. So I think I'll just stop here, and this is the basic storyline and the incident which led to this recent award by the PCA. I think I'll ask Deepak and Syam to go into the nuances of this particular case, and before that I hand over the floor to Nithin.
Thank you, Harish sir, for explaining the storyline so that everybody has a clear background of what has happened. May I request Advocate Syam sir to please join the discussion and give your opening remarks on the award and the facts. Especially, I would like to request you to clarify those gray area in the facts. There are a lot of facts being disputed and challenged, or many places. Of course, under many other circumstances, we have given a submitted set of facts. But beyond that, as a lawyer who have represented fishermen in Indian courts. We would like to understand the side of facts from you.
Thank you, Nithin. Let me begin by thanking CPPR and all others who have been instrumental in organizing this webinar. Dr. Harisankar Sathyapalan is a good friend, and I am happy to know from Hari that there is a group of people in Kochi who are deeply interested in law of the sea, and that they get together once in a while so as to discuss the latest developments and also the theoretical side of law of the sea. That is a very good development, and I appreciate Harishankar for being a member of that group and also for initiating this. My association with CPPR goes back. Anraj is a close friend, and I'm so happy that Mr. Deepak Raju is here. I've never known him before, and I look forward to the interactions with Mr. Deepak Raju. Well, the sole reason as to why I was invited for this, I assume, is the fact that I do teach maritime law in some of the universities here, and also the fact that I did appear for one among the two fishermen who were killed, actually for the relatives of those fishermen. So, coming into the points that Dr. Hari had succinctly explained the factual aspects, so we are spared of going into the facts. Well, we may have to see as to how the law would apply to the facts at hand and what the result would be, and how far the award that we have here meets the felt necessities of the times that we live in, and to what extent the Supreme Court's judgment, that is the highest court in India, Supreme Court's judgment, stands watered down by this award. Let me begin by mentioning a few aspects regarding law of the sea, because generally there is a perception that law of the sea in its entirety is represented by the United Nations Convention on Law of the Sea, which is in abbreviation termed as the UNCLOS or the UNCLOS, which is the 1982 UNCLOS to be specific. UNCLOS is a compendium, a collation of all those customary practices and principles of law of the sea, which were followed or practiced by the states. The term would be civilized states, as we use it in international law. And adding on to that, some new innovations, some new concepts were created by UNCLOS also. What we have to take note of at the first instance is that UNCLOS is not the final and the last source of norms in law of the sea. Law of the sea norms lies beyond UNCLOS also at some point of time. Having said that, it doesn't mean that UNCLOS doesn't have any relevance or UNCLOS can be superseded by other legal norms, or unless, of course, that can be done. But UNCLOS doesn't appear to be, especially in the 21st century when there has been a substantial norm-making activity in the law of the sea. UNCLOS may have to be updated to meet the requirements of the time. And we cannot look upon UNCLOS as the sole repository of all norms of law of the sea. Then, what are those provisions of UNCLOS which would be relevant to the facts of this case? Are the provisions of UNCLOS relevant to the facts of this case when it comes to the jurisdiction or the competency of courts in India to consider it? What are the local norms in India? What are the Indian national laws enacted by our parliament and enforced in India, which pertains to the matter? What would happen to all those judgments rendered by the High Court, also by the Supreme Court of India, in the light of this award? As the discussion of our topic goes, what are the takeaways for India in this? Well, I think that we should start with the Indian laws on the point. Because to me, the prime question is not as to whether in this particular case it was unfortunate for India to lose its jurisdiction or the Italian race, or whether the fishermen have been satisfactorily compensated. Compensation may come. My concern as a lawyer and also as a student of law of the sea is as to how the Indian law enforcement agencies and the Indian legal system would react if such an incident happens in the future. India has a very long coastline. This may be a rare incident where an Italian commercially owned vessel, we should not mistake the term Italian vessel mean it's an Italian sovereign vessel or a vessel to which Italian sovereignty would apply. It is a simple commercial vessel owned by a company. We don't know whether the company is based in Italy. It may be a flag that has been chosen by the owners for their own valid reasons. So it is a vessel which is privately owned, and on board the vessel, there are Italian Marines who are members of the elite naval force of Italy. There are hundreds of such vessels passing through the Indian coast. Tomorrow, there could be a vessel from another country, maybe flying a flag of convenience. There would be private maritime security guards on board, and the Indian coastline, especially during the morning times, especially I am told by the captains who engage in sabotage, that the coastal trade, vessels who engage in coastal trade, that by around 3 o'clock or 4 o'clock in the morning, if one goes to the bridge of a vessel which is passing along the Indian coast, you can see literally strewn across the horizon a number of fishing boats, all of them in different modes of fishing, different stages of fishing. So what exactly is in store for a fisherman? Two fishermen who are exercising their rights to fish within the waters that have been exclusively reserved for India have been shot dead. Well, they are being compensated. Would that suffice? Would the legal system in India and the law enforcement agencies find solace in the fact that they get a couple of crores of rupees? What is in store for those hundreds of fishermen who go to the sea every morning and they come back maybe 3 or 4 or even weeks later? Well, as it stands now, the Indian law on the point is very clear. But we will come to the award later. The Indian law on the point, as laid down under the 1976 Maritime Zones Act, varies from the UNCLOS. Is it right to vary? Would such a variation stand the test of scrutiny on the touchstone of international law? All these are different questions. For a policeman who is in the harbor police station in Kochi, who has been told and who has been empowered by valid documents issued by the central government, stating that harbor police station in Cochin has jurisdictional limit running up to 200 nautical miles of the Indian exclusive economic zone. And the harbor police station is entitled and legally competent to register cases and FIRs and investigate and proceed further with all those crimes that happen within this 200 nautical miles exclusive economic zone. The PCA award is of no consequence. He cannot say tomorrow that the PCA award has found that the Indian court doesn't have jurisdiction. Maybe not only with respect to territorial jurisdiction regarding the actual place where it occurred. Maybe let us for a moment assume that the sovereign immunity aspect was not there. It was by a private maritime security guards. Is there anything in this award which would say that had it been a private maritime security guards on board a foreign flag vessel, the way in which the Indian law enforcement agencies should have behaved should have been different? Or would they be competent to entertain a criminal petition or a criminal action against those private maritime security guards? Very doubtful. So we may have looked at the Indian law and the 1976 Maritime Zones Act, which specifically say that within the contiguous zone of India, India has an interest of security. We all know that the Laws Convention in Article 33 specifically provides only for 4 jurisdictions within the contiguous zone for the coastal state. Customs, fiscal, sanitation, and immigration are the 4 interests. There's a big clamor by even countries like India so as to include security as an additional interest in the contiguous zone. That was specifically declined, and UNCLOS as it stands now under Article 33 has only these 4 interests. But the 1976 Act of India specifically provides for a additional interest also. That's an interesting scenario. And the biggest take, if you ask me, from India, from this award, is the fact that even though Italy raised a specific point on this, because Italy challenged not only these contradictions in Indian law based on the specific provisions of the UNCLOS, they said that these provisions of Indian law, not only the provisions in the statute, but also the notifications issued by India, whereby the Indian Penal Code and Criminal Procedure Code have been extended up to the 200 nautical mile zones, should be declared to be illegal. Fortunately for India, nothing has been done. Nothing has been said about that. That aspect has not been dealt with. It is dealt with, and the court and the award says that it's not relevant, and they don't go into the merits of those claims, or rather doesn't decide on it, even though they discuss on it. So, as far as India is concerned, these laws remain. So, my answer to those policemen or the law enforcement agencies or coast guards who indulged in or engaged in the act of governance or keeping law and order along our coastline would be that they will have to abide by the Indian statutes on the point. The 1976 Act and as well as 1981 notification extending the jurisdiction up to the 200 nautical mile exclusive economic zone still governs the field, and tomorrow if such an incident happens, undoubtedly they cannot or nobody can take recourse to this PCA award and say that India doesn't have jurisdiction, even if it is not a sovereign immunity coming in. Now, after having said that, let us go into those aspects which are being portrayed as great success that India had. And we
Sir,
may have
excuse me, sir.
yes, please.
I think this is a break in the audio.
Is it so?
Yeah.
Am I loud and clear now?
Yes, it is. Yeah.
Okay, I will just. All right, all right. Just let me know if it's
Yes,
not
yes.
clear. Just let me know. All right. So there are certain provisions of UNCLOS. I think that I'm sure that Mr. Deepak will be going into it onto the theoretical side in a more elaborate way. But certain provisions of UNCLOS that we may have to take note of, so as to ascertain what exactly has this award done for us, are Article 87, 1A, and Article 90. The Article 87 pertains to the freedoms of the high sea, and Article 90 deals with the right of every state to sail its ships. So what is being now touted as the great success that India had is with respect to the right of Saint Anthony, which is a boat. From a theoretical point of view, a boat is not a ship, and it's not a flag state or a floating island of a flag state. Sorry, a floating island of a flag state. A boat is registered in Tamil Nadu. I think this particular boat was registered in Tamil Nadu. And in the usual maritime parlance, we don't call a boat as a floating island. Whatever it may be, very interestingly, rather carefully, PCA didn't go into that aspect. PCA would say that freedom of navigation is there, even if it is a boat or a ship or whatever it is. The freedom of navigation as guaranteed under Article 87(1)(a has been violated. And to that extent, India needs, or the people on board the boat needs to be compensated. And nothing beyond that. Therefore, my personal take on the matter would be that these are the two important aspects on which India can rather have a succor or rather have a relief, insofar as the Indian statutory norms were not declared to be illegal or rather invalid on the touchstone of international law. And on the other hand, the poor fishermen who had to feel the burn had been compensated almost adequately, and we hope that further compensation would be received by them. Beyond that, there's nothing much to celebrate in this particular award, according to me. And most of those provisions or most of those findings which have been laid by the PCA based on the provisions of UNCLOS, I find go against the Indian interests, and we should be pondering as to what went wrong and how to set it right. My specific concern is regarding the provisions as laid down in Article 58(3). Because just before I go to that, let me with Nithin's permission, for the sake of those who are not very well acquainted with the maritime zones here, let me just show to them the maritime zones for the purpose of their understanding. And I hope I will be able to do that.
Yes.
And I won't throw you out of the network while doing that because I'm not so computer savvy. Let me
No,
just...
you just have to share it. It'll
Yes. So I hope that you can see the slide. We are speaking of this particular zone, and I hope that you can see my cursor also moving. Territorial sea, and as Harisankar was pointing out, and as well as Nithin was mentioning, there were some factual disputes regarding, at the beginning stage, even regarding the exact location where this happened. The contentions of Italy and India did not match when it comes to the question as to exact area where this incident happened. The area assumes relevance because under the law of the sea and also under the local laws, the farther you move from the coast, the control or the sovereignty or the jurisdiction or whatever you call it of the coastal state progressively diminishes. So first assumes the question of baselines, drawing of baselines. And drawing of baselines itself is not a matter that has been easy to do. We have the normal baselines, you have the straight baselines, you have the Anglo-Norwegian fisheries case where it provides for a mixed baseline. So when it comes to, and we have a highly corrugated coast. So when it comes to the question of fact, the drawing of baselines would have been an issue had it been a trial court as to from where it has to be noted. Of course, we have our navigational charts where we have declared our baselines, and generally that should not be questioned. Within the territorial sea, that is the area where absolute sovereignty applies, and the Indian Penal Code and all the statutes of India apply with equal force within this 12 nautical mile territorial sea. So it's sovereignty in its pure and complete sense, except for some rights like the innocent passage right, which a foreign vessel would have through the territorial sea, which we are not concerned with, so we are not dealing with that at this point of time. Then comes the contiguous zone, which is a 24 nautical mile area, which would take in the territorial sea also, where the jurisdiction is with respect to only 4 aspects, which I mentioned earlier: customs, fiscal, sanitation, and immigration. And Indian law would say that within the contiguous zone, you have the security interest also. Then comes the exclusive economic zone, which is a larger zone, and it again starts from the baselines, wherein progressively the interest diminishes further to sovereign rights over the living and non-living resources of this area. So the question is, insofar as the international law specifically determines the territorial sea as the area within which the coastal laws can operate, was it proper on the part of India to extend it up to exclusive economic zone? And exclusive economic zone is that area which, under the United Nations Convention on Law of the Sea, is an area through which all vessels have, that is foreign flag vessels, have unhindered right of navigation. So if a foreign vessel is passing through the territorial sea, territorial sea, obviously the coastal state could have substantial control and jurisdiction over it. But if it is through the exclusive economic zone, it is doing it as of right. For example, here comes the next aspect which India had very validated before the PCA by saying that Indian law demands, or the Director General of Shipping has issued a notification which would say that any vessel which is the exclusive economic zone of India with armed personnel on board should disclose the details prior to the entry into the exclusive economic zone, which was not done by Enrica Lexie. The details as to what all things has to be disclosed is very specific. Even the number of guns on board, the number of ammunition, the number of bullets, it goes to such finer details. And all these things have to be disclosed as per the Indian law. This was not complied with by Enrica Lexie when it came in. And obviously, these were safeguards so as to protect the lives of Indian fishermen who are there on the exclusive economic zone, which is the area which is exclusively reserved for the purpose of India. I'm just giving you one more different view of the very same maritime zones and demarcation for the purpose of a better understanding, to know that contiguous zone is an area which lies so close to the coast, and whereas international waters outside the territorial sea, because here the contiguous zone, the exclusive economic zone, as well as the high sea beyond are from the point of view of navigation, international waters. Now, let me just stop the sharing and come back to the provisions that were dealt with in the award. One serious issue that arises with respect to the award is that it says very specifically that Marines have immunity. Dr. Harisankar was pointing out that these are the two aspects, whether India has jurisdiction and whether the Marines have immunity. Well, the marine immunity point which has been laid down in award is really surprising, because as far as the sovereign immunity concept is concerned, we no longer live in the era of Michel versus Sultan of Johor. Of course, we all have studied, all law students have studied Michel versus Sultan of Johor as the starting point of sovereign immunity. We no longer live in 20th and 21st century in the very same era where sovereign immunity was looked upon as very sacrosanct. We no longer follow the principles as laid down in Parliament Belge. All those students of law of the sea and maritime law would be aware of the dictum in the case of the Parliament Belge, wherein Parliament Belge was a Belgian vessel, which was a commercial carrier, which was a trading vessel, which as part of trading in private merchandise was also carrying the mail belonging to the Belgian government. Delivery of mail is a sovereign function. So merely because there is a mailbox on board the vessel, can it be said that the vessel would partake the character of a sovereign vessel engaged in a sovereign activity was the question. For different reasons, it was held that there is no jurisdiction in that case. But when it came to the 1982 UNCLOS, we all know that when it comes to the question of immunity of foreign vessels, there is a specific chapter in UNCLOS, especially while it deals with, explains innocent passage, where the categorization as government ships, commercial ships, and government ships operated for commercial purpose, and government ships which are performing sovereign functions. So when there is a categorization regarding government ships operated for commercial purpose, and when it is said that such vessels which come down from the status of a sovereign and engage in commercial activity and rather compete with the private merchant vessels, there is no question of extending sovereignty to the people on board that vessel, even if that vessel belongs to the sovereign. So the question is now. Sorry.
Sir, can I intervene and come back to you later sometime?
Perfect. I'm sorry to keep Dr. Deepak waiting.
No, it's not like that.
Let us hear him.
Yeah. Deepak sir, may I invite you with very short words? Please join us in the discussion with an opening statement. Also, I just like to request you to probably touch upon this popular issue. See, we have a lot of international law students and experts coming in the audience list, but there are popular people. I mean, people who don't actually study in the technical sense international law also in the panel. So for them, I would like to ask you this particular question. In a popular sense, we all heard that this has happened or this has an effect on Indian flag, a boat carrying Indian flag, and as rightly pointed out by Syam Kumar said that there is no identification of a boat as a vessel. But even in that case, as to clear that assumption that something happens in a boat, what is the jurisdiction, and from where does the preliminary question of jurisdiction come into play?
Yeah, thank you. So first of all, let me also thank the organizers of this event. It's a very interesting discussion, and I thoroughly enjoyed the remarks that have been made by Advocate Syam Kumar so far. And it's nice to be talking to people who are sitting in Kochi about all of these issues, because you're very close to where all of this happened. I've never had the pleasure of meeting Advocate Syam Kumar before, but my sister and my brother-in-law were both taught by him. He taught maritime law to both of them, and they both remember you very fondly, sir. So they were very happy to hear that I'm going to be speaking on the same event as you. So let me start by the question of what is the significance of a boat or a vessel carrying a flag, and what does it mean to exercise jurisdiction? And from there, I'll move on to a couple of points that I think are particularly important takeaways from this award. And the one thing that I really want to focus on is a question of incidental jurisdiction and the consequences of this tribunal saying it had incidental jurisdiction to decide a question of immunity. So to start, what does the word jurisdiction mean? What does it mean when someone is exercising jurisdiction? Every country, or in a technical sense for international lawyers, every state with a capital S, is sovereign, which means it has powers within its territorial limits. Within those territorial limits, it can make law, enforce that law on anyone who's within that territory, and on events that occur over the territory. Now, from the time people started this activity of going to the sea, there were questions about what happens when an incident occurs at sea. And customary international law developed to accommodate the fact that law had to apply not just on land, but also at sea, and vessels were going very far from land. In fact, the person who is regarded as the father of international law, Hugo Grotius, his significant contribution to international law was he was the one who argued for a principle called mare liberum, which means open seas. And his principles eventually got translated to the freedom of navigation on the high seas, which Advocate Syam Kumar has already touched on. Now, when an incident occurs on sea, and if that incident may be seen as, say, a criminal activity, there's a question of which state has the right to investigate the matter, impose punishment over the matter. That is what we call a question of jurisdiction. From the very beginnings of international law, that was always a contentious question. And customary international law and modern treaty law, as codified in UNCLOS, set out certain rules on who has jurisdiction. And those rules depend to a very large extent on where exactly in the sea this incident occurred. That is the different maritime zones that Advocate Syam Kumar was showing here. A state's sovereignty extends to the territorial sea, and then you see a progressively diminishing set of rights that a state has as you move further away from the territorial sea into the contiguous zone and the exclusive economic zone. And then you have the high seas, which are free for all. Now, another matter which affects the exercise of jurisdiction is the flag of the vessel. So every vessel which is seafaring is registered with or has the nationality of a particular state, and only one state. So that is a requirement under UNCLOS. Every vessel has to have one nationality and only one nationality. And one way of signifying that nationality, one way of signaling to everyone else that a vessel holds that nationality is to fly a flag. When a vessel is at high seas, it is only the flag state, meaning the state of which the vessel is flying the flag or has the nationality, which has jurisdiction over the vessel and people on board that vessel. Now, in this case, St. Anthony was a small fishing vessel, as Advocate Syam Kumar noted. And under Indian law, fishing vessels are not required to fly a flag. And St. Anthony was not flying an Indian flag when it came across Enrica Lexie. And one of the arguments that Italy raised during the proceedings was that St. Anthony, there was no evidence that it was an Indian vessel. There was no evidence that India even had the right to be advocating rights on behalf of St. Anthony, because it was not flying an Indian flag. But on that matter, the way the tribunal proceeded was a flag is a visible sign of nationality, but it's not the only way to evidence nationality. And even when a vessel is not flying a flag, it may have a nationality, and in this case, based on the evidence, based on the fact that it is registered in Tamil Nadu, the vessel St. Anthony was considered to be an Indian vessel. Now, I told you the nationality of the vessel affects the question of jurisdiction. The tribunal looks at what happened. So two states are claiming we have jurisdiction to try these offenses and the other one does not have jurisdiction. So each state is claiming exclusive jurisdiction. At that point, the tribunal starts its analysis with a principle called territoriality. Territoriality as each state has jurisdiction within its own territory. And that principle usually also extends to vessels which fly the flag of the state or has the nationality of the state, because vessels are considered in some sense to be floating pieces of territory. So based on territoriality, the tribunal says an offense commenced on board Enrica Lexie, because firing was done from Enrica Lexie, but it was completed on board St. Anthony, because people died on St. Anthony. So to the tribunal, this is an offense which is committed on board two vessels. And because of that, the tribunal says both states have concurrent jurisdiction as a matter of principle of territoriality to try these offenses. Now, if we were to go only by territoriality as a rule, India would be totally within its rights to try the offenses and continue with criminal proceedings. But then the tribunal turns to Italy's arguments on several provisions of the UNCLOS, where Italy says that even if India in principle has the right to try people for offenses such as this one, India exercised that jurisdiction on the high seas or outside its territorial waters, because while the vessel was 50-something nautical miles away, when Enrica Lexie was 50-something miles away from Indian coast, Indian Coast Guard and police intercepted and accompanied Enrica Lexie to Kochi. And to Italy, this would be a violation of Articles 97 and 99 of UNCLOS, which are about freedom of navigation on the high seas. Now, those provisions are also applicable in exclusive economic zone by virtue of Articles 56 to 58 of UNCLOS. So, although exclusive economic zone is an area where we have exclusive rights over the resources, in matters of navigation, UNCLOS Articles 56 to 58 provide that the freedoms which apply in the high seas would apply. So Italy was complaining that in a place which was like the high seas in matters of freedom of navigation, India had exercised jurisdiction over the vessel, and that was a violation of Italy's exclusive right over its flagged vessel. Now, here, India actually gets very fortunate. So when you look at the facts as they appear on the record, there's a complaint filed with the police station, and Indian police and Coast Guard go out to the sea and they do certain boarding drills. They make attempts to contact Enrica Lexie. There is an aircraft which flies very close to Enrica Lexie and instructs them to turn back to Kochi. Now, the captain of Enrica Lexie testified before the tribunal that he entered Indian territorial waters because someone told him that pirates had been arrested, and Indian authorities told him that pirates had been arrested, and he was required to provide some evidence. So he entered Indian territorial waters to voluntarily to provide evidence and to assist the authorities. Now, the tribunal says, look, Indian authorities requested him to come to Indian territorial waters. He did so voluntarily under the belief that he could change course again whenever he wanted and leave. And only after the vessel reached Indian territorial waters did India actually exercise any kind of compulsion, any kind of power over the vessel and its crew. So to the tribunal, there was no exercise of jurisdiction when the vessel was at the high seas or in the exclusive economic zone. The exercise of jurisdiction by India commenced only after the vessel entered Indian territorial waters. And that saved India from all of the claims of violation of UNCLOS that Italy raised. And tribunal said, look, there's no violation because no jurisdiction was exercised. So at this point, it looks like by bringing the vessel back and then initiating criminal proceedings, India has not violated any provision of international law, right? So all the provisions which Italy cited of UNCLOS were considered, and the tribunal rejected them. But then came a separate argument that the Marines were entitled to immunity, and this is something that Advocate Syam Kumar has touched on. But this becomes the turning point of this whole dispute. Italy claimed that the Marines had immunity because they were officials of Italy. And under customary international law, officials of a state are immune from the jurisdiction of foreign states while performing their duties. Italy cited a number of provisions of UNCLOS to say that these provisions would make that customary international law immunity applicable in the present dispute. But the tribunal rejected all of those citations to UNCLOS provisions, and this had to be decided on the basis of customary international law. Now, what is interesting is Article 288, Clause 1 of UNCLOS defines the jurisdiction of courts and tribunals hearing the dispute under UNCLOS as resolving any disagreements relating to the interpretation and application of UNCLOS. But this question of immunity was one concerning customary international law. This is not one which could be resolved by interpreting or applying UNCLOS. At that point, India argued that the tribunal did not have jurisdiction to hear that particular aspect of this dispute. This is outside UNCLOS. The tribunal then says, we have incidental jurisdiction. And the way the tribunal, so this is a preliminary discussion that happens before the tribunal discusses all of the merits of the case. At that point, the tribunal says we have incidental jurisdiction because it's conceivable that Italy can state its claim without reference to this incidental matter of immunity. The main arguments here, the main thrust of the dispute is UNCLOS, and it's conceivable to resolve this dispute without reference to immunity. And for that, they cite a case of the Permanent Court of International Justice called Certain German Interests in Upper Silesia. I'll come to that case in a moment. But having asserted jurisdiction based on this idea that this is an incidental question, when the tribunal progresses with its analysis, it's rejecting all of Italy's claims, and then only immunity remains. And that becomes the turning point. And the tribunal then says, under customary international law, state officials do have immunity from foreign state jurisdiction. India raised an objection to that. India raised a exception called the territorial tort exception. That is, for those of you who have heard about a case called the Rainbow Warrior. Rainbow Warrior was a case where French agents went to New Zealand, and in New Zealand's port, they bombed a Greenpeace ship. And they were charged with criminal liability. And then there was a dispute between New Zealand and France. And it was understood that agents do not have immunity if they engage in criminal conduct within the territory of the country which is exercising jurisdiction. Now, in this case, that principle was rejected because of two reasons. One was the criminal conduct occurred outside the territorial waters, but more importantly, the tribunal says for that exception to apply, the agents should be in the territory of the country which is complaining without the knowledge of the country and sort of sneak into the territory of the country, and they didn't believe that to be the case here. So they rejected that exception, found that the Marines had immunity, and that was the reason why they ordered India to cease all of its proceedings. The tribunal also considered India's counterclaims, and they found that conduct of the Marines was attributable to Italy, and they had violated the rules on freedom of high seas or freedom of navigation at high seas because they fired at St. Anthony, and that was an obstruction of navigation, and that was exercise of jurisdiction where they shouldn't have exercised jurisdiction. So based on all of that, the tribunal also found Italy to be in violation of UNCLOS and asked Italy to pay compensation. The question of incidental jurisdiction and what it means goes on. Yes, someone trying to say something?
There was some interruption in the audio.
Sorry. I don't know how much everyone heard, so let me try to say the last thing I said.
Sure,
okay.
Sir, go ahead.
Can you hear me now?
Yes.
So the questions of incidental jurisdiction and how that is dealt with is not something that's restricted to law of the sea. It opens a problem that will have to be dealt with in front of almost all international adjudicators, because the jurisdiction of international adjudicators derives from the consent of states. If states don't consent in one way or the other, no international court or tribunal has jurisdiction to hear a particular matter. And that often results in only one particular part of a dispute being submitted to one adjudicator and not the entirety of a dispute. And that's fine. That's the way international law has always operated. But here, the tribunal seems to be saying that we have vast incidental powers to sweep into our jurisdiction matters that may be outside the treaty with which we are dealing, or the treaty from which our powers derive. And that's a matter on which two of the arbitrators wrote very strong dissents. One is Dr. P.S. Rao. He was India's nominee as an arbitrator. And the other was arbitrator Robinson. The two of them dissented vigorously with this assessment. So incidental jurisdiction is something that India has to keep its eye on, because India is a frequent litigator in some of the systems of international dispute settlement. And if this line of thinking is allowed to take roots in international dispute settlement, that will be a problem for countries like India, who have traditionally guarded from certain disputes being submitted to international courts and tribunals. This is a matter on which I've written, and it's going to be published on the Opinion Jurist blog. For those of you who watch that blog, it may be a good idea to read it. It's not published yet, it's coming soon. Now, apart from that incidental jurisdiction question, what other lessons are there for India? I think the most interesting one is the fact that the 1976 Maritime Zones Act it asserts broader powers for India than what UNCLOS gives. In this case, the tribunal left that question aside, saying that even if India had exercised jurisdiction, that was not necessarily because of this 1976 Maritime Zones Act. And there was a way to deal with the dispute without looking into whether or not 1976 Act was a violation of international law. Now, as Advocate Syam Kumar said, that the Act, Indian law, continues to guide the actions of everyone tasked with enforcing Indian law, including policemen at the Harbour Police Station. But at a higher level, at a policy level, Indian government needs to give close thinking to 1976 Act and its relationship with UNCLOS. And to the extent there is a conflict with UNCLOS, we need to explore whether there are ways of achieving some sort of consistency between the two. Apart from that, as I hinted earlier, the fact that the tribunal looked at the circumstances which made Enrica Lexie turn around and come to Cochin and said that India was not exercising jurisdiction. We made a polite request and they turned around. That was the reason why India had not violated provisions of UNCLOS. But tomorrow, if something happens and if a vessel is outside Indian territorial waters, and if they don't turn around pursuant to polite requests, if Indian officials exercise actual power, if they have to either use force or threaten force or do it as a matter of authority, then there would be a violation, or there may be a violation of UNCLOS, and that is something that Indian government needs to be aware of and sensitive to. The question of sovereign versus non-sovereign vessels, which Advocate Syam Kumar touched on. So there's a categorization of vessels, and in this case, the vessel was a commercial vessel. But the tribunal's finding of immunity hangs on the fact that the Marines who shot were Italian state officials. That's the reason why they had immunity. If they were a private security firm, I don't think the customary international law on immunity would extend to them. Interestingly, Italy has actually done away with this program under which they could send Marines on board commercial vessels to protect them. So at least for Italy, it's not a practice right now, but I understand that kind of practice may exist in other countries, and state officials, Marines of other states may be present in vessels coming to Indian waters. And that does raise questions of immunity and how to deal with it. So everyone should be, the authorities should be mindful of it, note that fact. Now, one last thing on which I'm not an expert at all, but I need to touch on, is the fact that St. Anthony and Enrica Lexie happen to be in extremely close proximity of each other. Now, the facts differ somewhat in the telling of different people and different witnesses, and based on which side they are representing. But when you sort of distill all of those facts and see what is common between them, it appears that everyone, including the captain of St. Anthony, agreed that the vessels were about 100 meters or 80 meters from each other. Now, I don't know if there is any Indian law, and this is something that Advocate Syam Kumar could touch on. Is there Indian law on how close to each other vessels should come, how they should conduct while they come to those kind of close proximity, and how is that enforced? And do we have some sort of training programs for the Marines, for the fishermen and for people operating small vessels about the risks of coming close to larger vessels? And that's something we should pay attention to. But in this case, India had made an argument that Enrica Lexie, when Enrica Lexie and St. Anthony came close to each other, St. Anthony had the right of way based on which side it was coming from, just like you would talk about a right of way on the road, who should stop and let whom pass. India had argued that St. Anthony had the right of way, and Enrica Lexie was a much faster vessel, and they could have moved away. Now, that's not something on which the tribunal has made an affirmative decision. So India needs to give some thinking to matters of right of way, matters of safety, how close vessels should come to each other, and either speak about the laws on that matter or provide trainings to people operating vessels. At the end of the day, what comes out of this decision is India does not have jurisdiction over the Marines. The fishermen, the victims, will receive compensation. And there's going to be a criminal investigation in Italy, and India has the opportunity to provide evidence input into that process. So it's not the end of the road. It's the end of the road for criminal proceedings in India. But given that there are proceedings which will happen in Italy, India still has the opportunity to contribute to that process and make sure that the investigation is supported in every way India can support it, because a lot of the evidence lies with India, and to the extent India is interested in seeing criminal penalties imposed, it would be in India's interest to support those proceedings as well. So I'll restrict my initial remarks to that, and I'll come back for any other questions you have. Thank you.
Thank you, Deepak sir. There's a request to the audience out there that you can type in your questions in the chat box or even in the comment box in the Facebook stream. Our research scholars from CPPR will be posting it up in one of the sheets where we could read it out to the speakers. So before that, we have already received few questions during the time of registration itself. Based on that, we have prepared few questions. Let me take a start on that. First question probably I could ask to Deepak Raju sir, because he just now finished speaking about jurisdiction and immunity. So International Law Commission itself had a work on the immunity of state officials, and they were not able to finalize on what is the way of kind of immunity afforded to people other than the high state representatives. So, and especially these kind of arguments like a Marines or a police officer having immunity while performing their official duties could be probably tested or tested in the forum court, like how far he was performing the duties, whether he was reckless in that, whether he was performed after due diligence. All these things could be, as a matter of a question of fact, could be examined by the forum state and accord immunity to like that. So if India accepts this judgment award, and then as we have already seen, India central government has placed a request before the Supreme Court to withdraw the criminal proceedings. How would it affect the customary practice of India in terms of according immunity to the foreign officials?
Thank you, Nithin. That's actually a very good question, and that's something I wanted to touch on, but I stayed away from in the interest of time, so let me get to it. So when you speak of immunity, jurisdictional immunity, there's a little bit of a difference between immunity of a state and immunity of individuals deriving their immunity from the state. The customary international law on immunity of states is fairly well established, and that is a corollary of states being sovereign and equal, sovereign equality of states. And the latest decision on that is probably the ICJ case, jurisdictional immunities of states between Italy and Germany. A claim was brought by Germany because Italian courts were entertaining civil claims against Germany for harm done to individuals during the Second World War. And eventually, at the end of that discussion, where ICJ landed was that states are, as a matter of customary international law, entitled to immunity from foreign jurisdiction. And there is no exception to that immunity in customary international law, based on what kind of actions you're complaining about, such as grave violations of human rights. So there's no exception based on the kind of conduct that is at issue. That is the immunity of states. But when you talk about individuals who derive immunity from the states, such as the head of the government or of the state, foreign minister, and then you move down the chain to policemen, the law is not as well developed. It's not as well codified, and you don't really see consensus among states on what that is. So at the highest level of people representing a state, sitting presidents or foreign ministers, generally there is immunity, functional immunity. Now there is a debate in international criminal law about whether that immunity can be diluted in favor of trying certain grave offenses against humanity or certain violations of human rights which raise to a certain threshold. Now, when you move down the chain, the reason for that functional immunity sort of gets diluted. The reason for functional immunity is the role of a head of state or foreign minister just requires immunity, and without that immunity, they cannot perform the duties that they have to perform. But when you come down to someone like a policeman, the first question is, why would he be doing an official act in the territory of another state or outside the territories where his state has jurisdiction? In this case, remember that Italy also did not have jurisdiction in the place where the shooting happened. And Italy was actually found to have violated provisions of UNCLOS by exercise of jurisdiction by this Marines shooting. So why would a policeman, why would a Marine be doing an official act in a place where the state itself does not have the power to conduct, power to exercise jurisdiction or to undertake official business? And that's a question that troubles me. This tribunal just doesn't engage with that question. They sort of jump from jurisdictional immunity of states to jurisdictional immunity of individuals. And there are several missing links in between. And as I told you, immunity was the point on which 2 of the 5 arbitrators dissented, and the dissents are quite powerful. And I don't see any reasoning in the tribunal's majority award which bridges that gap between immunity of the state and immunity of individuals.
Thank you, sir. Harisankar sir, you want to step in?
Yeah, maybe with the permission of the moderator, can I ask? It's a quick question. Maybe I can first pose it to Advocate Syam Kumar, then Deepak can also give you insights. So what I see from this short award is, of course, the most important point, as Deepak just mentioned, it is the question of immunity. Though the award or the tribunal says that India has no jurisdiction and the criminal jurisdiction lies with the Italy, but nowhere in the award it basically it is not countering, or it is not saying that India has violated the basic prescriptive jurisdictions mentioned under UNCLOS, which says that India has not basically violated. So my quick question is the immunity question the reason for depriving the jurisdiction from Indian side and giving it to the Italy, not because of the prescriptive jurisdiction aspects contained under the UNCLOS or under international law, or is it just because of the immunity question the tribunal is tempted to give Italy the jurisdiction and deprive India of the jurisdiction? And second point, as Deepak was mentioning, so how does an international tribunal or a court, because one of the statements say that taking note of the commitment shown by Italy in their domestic criminal legal proceedings, we are giving the jurisdiction to Italy. So how do you ensure that this commitment is continued? Any one of the panelists, please. So is immunity the reason for giving jurisdiction to Italy, and the second, domestic amendments?
Hari, if I can step in with the permission of Advocate Syam Kumar, if I can go first. So yes, on your first question, the answer is simply yes. Immunity was the only reason, and I stress the only reason why this tribunal said every single provision of UNCLOS that Italy had cited and found there's no violation, there's no violation, there's no violation, and then turned to the issue of immunity, which they had said in the beginning was an incidental issue. And based on their finding on immunity alone, they gave out the award that India has to cease criminal proceedings. Now remember, the reason why they assumed jurisdiction over the question of immunity in the beginning was This dispute is capable of being resolved without reference to immunity, and that is what makes it an incidental question. But had they resolved the case without reference to immunity, they would have come to a completely opposite conclusion. The only reason why they came to the conclusion at hand is immunity. And what they cite in support of what they did is the PCIJ case in the case concerning certain German interests in Polish Upper Silesia. Now that was about a Geneva treaty between Poland and Germany, and that had certain provisions regarding how they would treat each other's property. Germany said that Poland had expropriated some property, and Poland responded that no, we have not expropriated that property, and violated the Geneva Convention by expropriating. And the reason for that is because the property doesn't belong to Germans in the first place. And the property does not belong to Germans in the first place because, and Poland cites a provision of the Treaty of Versailles in support of that proposition. Now, Treaty of Versailles was not something on which the PCIJ had jurisdiction directly, but the PCIJ says interpreting the Treaty of Versailles to determine who owns this property is a preliminary question that we need to undertake to decide whether or not there has been expropriation. And that's natural. To decide whether or not property has been expropriated, you need to first decide whether or not the property belonged to the party complaining of expropriation. Now, the tribunal here relies on that decision as support for examining a claim under UNCLOS, coming to a conclusion under UNCLOS, and then saying outside UNCLOS there are certain norms which lead to the opposite conclusion, and that conclusion prevails, and therefore India has to cease what they're doing. And that to me goes a lot beyond the way we have understood incidental jurisdiction so far in international dispute settlement. And on that point, I quite agree with the way the dissenting arbitrators have approached the issue. Now, on your second question, how is this commitment to undertake criminal proceedings enforced? This is actually usual practice in international litigation that states make certain undertakings, and the courts and tribunals note that commitment in their judgments, and it is understood that the state will follow up and perform on that commitment as a matter of good faith. And some of you may be familiar with a case before the ICJ called nuclear tests between France and New Zealand and Australia. So at some point, France was undertaking aerial nuclear tests, and New Zealand brought a case against France. And while the case was pending, France announced, we are not going to do aerial testing anymore. And at that point, the ICJ decided to stop the case based on this commitment, saying that, okay, France has agreed. And they made a few statements on the value of unilateral declarations of states. And they found that this creates a binding commitment for the state. So in the present case, I believe that Italy's commitment, which it made to the tribunal, which is recorded in the award, creates a similar commitment for Italy to undertake those criminal proceedings and investigations. And that commitment is a binding one. And if Italy does not follow through, there may be ways to find a way back to another adjudication on that question.
Syam sir? Yeah.
You need to unmute.
Oh, that was very informative. Thank you, Mr. Deepak. And I don't think that I have anything more to add on to that, but rather I would request him to let me know as to what exactly is the present position regarding this functional sovereign immunity that could be exercised by military personnel in a foreign country when they are faced with criminal charges there? To what extent does it at present protect them? Or is it available, or is it something that is, as you rightly said, it comes down from the hierarchically, it trickles down, and when you come towards the lower levels, it is almost non-existent. Deepak, can you help me on that?
Right. So, immunity of military personnel abroad, it depends on the reason why they're abroad. So if they are in a situation of war and they go to a country to fight a war against that country, if they're captured, they're prisoners of war, and the Geneva Conventions apply, and there are rules on how they must be treated, how they must be repatriated, and the prosecution of war itself would not be a crime. But if they have committed war crimes, the state which is capturing them would have the right to try them, and there would be no immunity. But in peacetime, if they're in a particular country, it depends on whether they're there by invitation, say to help in a humanitarian relief. And if they're there by invitation, typically states would have an arrangement between themselves on who has control over them, who has jurisdiction over them, etc. And the customary international law on this has not really developed a lot. So if a military personnel is in a state at peacetime for, say, relief work, and he commits a crime which is outside his regular duties, he commits a crime, the general understanding is that the state where he's present would have jurisdiction, but the closer you move to the duties of the person, the closer you move to whether or not he's doing that act in the course of his duty, there's a lot more ambiguity. A lot of times it's dealt with through treaties or the terms under which he is sent to a foreign country. But where those terms don't exist, there is quite a bit of ambiguity and there's a lack of consensus.
Oh, okay. Interestingly, we had a case here, even though not squarely on the question of sovereign immunity, another maritime matter involving the Seaman Guard Ohio, which is a private maritime security guard vessel, which was caught within Indian waters. And interestingly, some of the contentions, though, they took, because it was a floating armory, and there was a huge amount of ammunition and arms that was recovered, and squarely against the norms as laid down by the Arms Act of India. And they were found within the Indian territorial waters, interestingly. So totally different scenario altogether. But the contention that was taken was that we were discharging a function that was akin to what the Indian Navy is doing in a pirate-infested waters. And so when we are discharging duties which is akin to the duties discharged by a sovereign military body, we should also be able to give this to the protections, at least to a reasonable extent, was the contention. So what exactly are the parameters of this? Because when it comes to, we have a serious problem of this differentiating between a merchant vessel and an armed vessel as it stands now. Because with formerly, at the time when 1982 UNCLOS was made in and the territorial sea and innocent passage principles were laid down and they categorized it as armed vessel and merchant vessel, they may not have thought of the situation at that point of time. But now we have a merchant vessel, or rather an armed vessel masquerading as a merchant vessel, or the kind of risk that a coastal state and especially the fishermen exercising their rights in the EEZ, they face the same kind of risk. So it's a moot point. I fully agree with you as to the contemporary laws still developing, and well, we may have to wait for more incidents like this to come.
Right. So just to clarify on something. So when private entities claim we are performing a function akin to what a state Indian Navy should be performing, the question is who authorized you to perform that function? Because immunity flows from attribution. Whether or not this is a sovereign act, whether or not this is an act which is performed on behalf of a state. So I guess Advocate Syam Kumar is familiar with the story of privateers long back at the time, even before like all of these laws of the sea developed. When the seas were quite a dangerous place, you had pirates and privateers. The difference was that privateers operated with some sort of a charter from one government or the other, which said, don't touch our vessels, but they're allowed to take all the vessels off. So they were private actors, but they had an authorization from a government to do certain things. Now, of course, that charter was valid only if you got caught by the country that gave you the charter. If England gave you a charter saying you're free to attack French vessels, but not our vessels, and you get caught by France, you would be hanged, and there was no showing the charter didn't really help you. But the idea that a state can entrust some of its functions to a private entity is an old one, but now what's happening is, as Advocate Syam Kumar says, in patrolling the sea, you have a lot of involvement of private actors, and the law hasn't developed correspondingly. But if you are to look at it from the traditional international law angle, the first question you're going to ask is, under whose authority are you acting? Is your act just akin to a sovereign act, or is it a sovereign act? And that's the first question for any assertion of immunity.
Thank you.
Thank you, speakers. Let me take some questions from the audience right now. This is from Aditya Roy from South Asian University. His question is really interesting, that he had asked that India is making an argument that the name of the case should be St. Anthony incident rather than Enrica Lexie incident. So his question is about the power of narrative over the people and also on the tribunal.
Interesting. Yes, indeed. Actually, the award starts off with this confusion as to whether it should be termed as the Enrica Lexie incident or the Saint Anthony incident, and finally the award settled down, and the arbitral tribunal says that we would better call it Enrica Lexie incident because we have all along been calling it that way, not for any other reason whatsoever. But of course, it has not only emotive elements behind it. But I understand that one of those, as Mr. Deepak was rightly pointing out, this effect doctrine of jurisdiction, the effect doctrine of jurisdiction. We had a strong contention because when I appeared here, one of the contentions that was taken in support of me by the central government was that Saint Anthony is a floating island of India. Well, I did find some serious loopholes in that contention at that point of time itself. But I think that India took it up to the level of PCA to say that this is an incident where cause and effect theory would mean that the effect was on Indian territory rather than the way in which the Italians would contend that it is something that would squarely remain within the limits of its floating island. I think Deepak may be able to put more light on it.
Right. So let me just add a couple of thoughts on that. So when I see the award, there's a discussion of this, whether the dispute should be called the Enrica Lexie dispute or the St. Anthony dispute at the beginning, and then it comes back a little bit later. And the tribunal's decision essentially is that, as Advocate Syam Kumar rightly put it, we've always been calling it this, let's call it this. That raises an interesting question of how are disputes named, right? And this is something that applies not just to law of the sea disputes. This is true in, say, the disputes before the International Court of Justice or the World Trade Organization or many other disputes. Disputes have a name. And that name, when you hear it, it tells you something about what is the story about. And that's the first thing you often hear about a dispute. But very often, the name of the dispute is assigned by either the party who starts the dispute and I say and or because they both sometimes have a role, by the secretarial staff assisting the judges making the decision. So in the PCA proceedings, it's not a permanent, in the Annex 7 arbitration, it's not a permanent arbitral body. The Permanent Court of Arbitration is the administrative body which assists the arbitration, but they're not the ones deciding it. The arbitrators are to be picked by the parties, and if they fail to pick the parties, there's a procedure under which the president of the laws will appoint the arbitrators. So once a dispute starts, there's a period of time during which there's no arbitrators, and a number of important administrative functions are happening in the background. And those functions are being handled by the institution which runs the arbitration, in this case PCA. In WTO disputes, there is the WTO Secretariat which would perform similar functions. In the ICJ, although you have permanent judges, you would have the registry performing some of these administrative functions. So a lot of times, naming a dispute is simply an administrative matter to which most people don't pay a lot of attention. But then as the dispute progresses, a party may realize that the way a dispute is called may not evoke the image that it wants to project, and it probably favors the image that the other side has. But by then, the dispute has been called by that name for a long time. So in this case, Italy started the proceedings. They called it the Enrica Lexie incident. The PCA registered that as the name of the dispute. And by the time India said, can we change the name of the dispute, the tribunal said, we've come this far. Now, of course, that doesn't drive any of the substantive analysis of a tribunal. The interpretation and application of the law remains the same, whether you call it the Enrica Lexie incident or the St. Anthony incident. But the fact remains that it was called Enrica Lexie incident. And that's a choice which was made at a very, very early stage. And that's a choice which India went along with until it challenged that decision quite belatedly.
Thank you, Deepak sir, for the answer. So, in terms of discussing narratives, I would like to ask you, like, how far the narrative of the human rights of fair trial came up in this case, because we know that there are a lot of sentiments being bring up in India, and especially because there was politics involved, even calling out our opposition leader's name and other kind of things which is happening around it. So does that public sentiments affected this kind of a arbitration, or it motivated this kind of an arbitration?
No, not in the award, because in the award, the tribunal was very clear. They were not going to get into whether or not the Marines were individually liable. So they were not getting into whether there was a crime committed and who was responsible for that crime. They say their task is to decide which state has the jurisdiction to determine those questions according to domestic law. And they decided as Italy based on the immunity argument. And they're leaving the questions of wrongdoing, criminality, to be determined by Italian courts. And they say let Italian courts take a decision based on wherever the evidence leads them. There was a discussion about the condition of detention of the Marines in India. But again, Italy was not making an argument that they were poorly treated or badly, the trial was unfair in any way. Italy's argument was India just did not have the power to do this because their immunity. So fair trial, human rights, there is some stuff in there where the tribunal says it's regrettable that there was loss of life, and we don't neglect the importance of that factor. All of that they do recognize, but in the discussion on the law, none of that really had any influence. It is all about, as a matter of law, who has jurisdiction, and that was the only question that the tribunal was answering.
If I may, just a sec, since we are on the point, something that was interesting was this award was rendered on 21st May 2020, as we can understand from the award itself, 21st May. But the experts of the award, it was published only on July 2nd. Up till now, as I understand, this award, because I don't know the procedure there. They may be having rules there. I think that Deepak, being the person there, he may be able to tell us as to what exactly is this delay. Because if it was an award that was rendered on 21st May, why is it that there is so much delay? And even on July 2nd, they are only sending us some outlines of the award, and the entire award is not out. We all here who have been waiting for this award get a copy of this award only when the central government annexes this to their petition there. So what exactly is the reason? Don't they have this fair process of disclosure there? And why is this such kind of a delay? Because some type of conspiracy theories were put forth on that also here. So I just wanted to clarify.
Right. So the reason is fairly simple, and it's not as interesting as the conspiracy theories. It's quite boring. The reason is under the Annex 7 Tribunal's rules, the award is provided confidentially to the parties, and the reason for confidentiality is there may be some evidence that the parties have provided to the tribunal which is sensitive in nature, and they don't want it to be part of the public record. So the parties are allowed a period of time when they review the award and make sure that there's no sensitive information there. And if there is any, they can ask for redaction of that sensitive information. And only once the two parties have said we have reviewed and there's no sensitive information, is the award in its entirety published on the PCA's website. So the PCA will publish it. But at this point, India has filed it before the Supreme Court, which makes it publicly available. I don't know if they obtained some sort of special permission from the tribunal or had an agreement with Italy allowing them to do that. But under the normal course of procedure, the award itself should remain confidential until parties have had the chance to review and it's published.
Thank you.
Very helpful. Thank you.
Thank you. Mr. K.V. Thomas, Senior Fellow of CPPR, would like to discuss the concepts of juri imperi and juri justinos, how these concepts get applied in this case.
Right. Is that to, can I comment on that first?
Yes, please. Probably we can make it speed up because it's already.
Yeah. So the difference is you understand that states can perform two kinds of actions: imperial or sovereign actions, and the general or commercial actions. And for a long time, it has been suggested that immunity extends to sovereign actions and not to commercial actions. And this became an issue in the Italy versus Germany case that I mentioned earlier. And the court at that point did not get into whether or not there's an exception to immunity in commercial activity. So when a state is engaged in commercial activity, whether or not it has immunity, there is something that the court did not have to address there. In this case, of course, the Marines are sovereign officials, but they were deployed on a merchant vessel. To the majority of the tribunal, the Marines were still performing a sovereign act by protecting the vessel. But the dissenting judges disagree, and they say that Marines were not engaged in sovereign action, and therefore they were not entitled to immunity. And they draw on a number of factors, including that the shipping company had to pay for their services. So according to the majority, this is still imperial or sovereign action which enjoys immunity.
Shamsar, shall I ask the next question? Okay, so this is from Dr. Dhanuraj, Chairman of CPPR. What are the amendments or changes that India should look into to bring in its policy or legal framework so that such incidents in future gives India a safe footing. Yeah, Syam sir, could you please unmute?
Very interesting, because the first thing that we should be looking at is a relook of our SUA Act of 2002. Because SUA Act, as Mr. Deepak was pointing out, maybe at the functional level of this policeman or the Coast Guard, the existing laws as they stand now may not create much of a problem practically, and maybe even handy when it comes to incidents like this that could be repeated. But on higher levels, it could be embarrassing for India maybe at a later point of time. There are a number of statutes, because like, for example, the SUA Act of 2002, I'm sure that Mr. Deepak would have taken note of it, which would say that we have 200 nautical mile criminal jurisdiction under the SUA Act. And I was one of those first persons who wanted to invoke SUA against the Italians. And I understand that it sounds kind of cranky to allege that SUA is to be used against the Marines. But the point was that as a lawyer for the fishermen at that point of time, I found SUA to be the most convenient and handy statute. So I filed a writ petition before the High Court of Kerala immediately after I was engaged, saying that this is a case where SUA has to be invoked. And all those provisions of SUA, whoever is listening to this, I would just request them to go through the SUA Act of 2002, especially the definitions therein, and also it's a compact compendium, a complete code which provides for procedure, punishment, and all those aspects with respect to marine offenses. And SUA Act, Mr. Tharuraj, is interesting in the sense that it punishes death with death, and also it provides for a shifting of burden. That is something that I found so interesting. If I was able to get 1 crore for my client at Cochin, thanks to the High Court of Kerala arbitration, it was mainly because of the SUA Act, because the first thing that the Italians wanted me to do was to withdraw this writ petition, not the Admiralty suit. They said, withdraw this one, because this is something that is causing a lot of embarrassment to the central government, because central government incidentally took, I think, if I remember right, 3 months' time, because the vessel was about to go. I was feeling all kind of heat so as to ensure that the matter is settled. The vessel, if it leaves without settlement, I knew that my clients would be left high and dry. After all that they have, the poor fishermen that they have at present is that 1 crore rupees each, which they got, nothing else. Now the Italians have left. So there's nothing much that remains as far as these poor people are concerned. It's just that SUA Act that clinched the issue for us, as I feel it. Yes, there are many statutes. For example, the 1976 Act, incongruencies therein. I think there is a need for relooking into all these statutes. And I personally feel that UNCLOS, many of the provisions of UNCLOS which restrain the state's jurisdiction, especially criminal jurisdiction, to 12 nautical miles are outdated. If you, I would request Mr. Deepak's opinion on this. International customary practice as it stands in the late 20th and 21st centuries would show that all these states exercise the criminal jurisdiction up to 200 nautical miles. So, under 138 of the International Court of Justice Protocol, you should be looking at the practice of states, and a new norm that has created in law of the sea should be taken note of. And this situation where it is confined to 12 nautical miles should be struck down.
Right. So that actually raises a very interesting,
I understand
fundamental philosophical question of a relationship between custom and treaty. So treaties, the Vienna Convention on Law of Treaties sort of codifies all of how treaties are to be dealt with in international law, and a treaty cannot be modified by custom. Typically, it has to be amended through a written amendment. So UNCLOS will have to be, if an amendment is required, it will have to be amended in writing by the states. Now, it is true that states exercise some sort of jurisdiction all the way up to 200 nautical miles, and states sort of differ on what kind of jurisdiction they can exercise. So the language in UNCLOS, which deals with what the powers in the exclusive economic zone are, is kind of interpreted in different ways. There are states which apply some kinds of criminal law in the 200 nautical mile zone. There are states which believe that if an offense has been committed in either the territorial sea or in the contiguous zone, you can take enforcement action with respect to that offense in 200 nautical miles. There are states which believe that you can take action against offenses which actually occur in 200 nautical miles. And you get all kinds of permutations and combinations on what kind of offenses states are talking about. So if some sort of confluence of opinions emerges, at some point this will be a ground for amendment or at least further elaboration of unproposed rules on this.
So with the permission of all the speakers and Shannu Madam who's waiting for long, let me take the one last question. It's from Ajmal Farhan. So his interest is to understand how to deal with question of facts in these kind of cases. Like how are we going to prove that this thing has exactly happened in our which part of the sea? How does Italy disprove it? These are the things he would like to know. I would also add one question into this is to understand the real human consequences of this award or kind of granting immunity to officials, like how far difficult it is to identify a pirate vessel and mistake it with a fisherman's vessel. How does it affect with economic activities specifically to Arabian Sea or Bay of Bengal or Indian Ocean? So that would be the last question, and then of the answers we'll move to Shannu Narayan. We would like to hear from both of you. Thank you.
Do you want to go first?
No, please go ahead. Please go ahead. I think that you are more fit to answer that, I would suggest.
Okay. Sorry. Can you just remind me what the first question was once again? Nithin, can you just remind me what the first question was? How are the facts established? Yes, I got that. Yeah, so facts and international dispute settlement, there's no codified evidence act for international disputes, but international tribunals, courts and tribunals have developed their own practice with respect to which side should prove facts, burden of proof, how facts may be proved, and what level of proof is required, standard of proof. And all of this varies depending on which tribunal you're in, what kind of a question you're dealing with, and what kind of evidence is actually available. So in this case, given that this is a maritime incident, the logbook of the captain was particularly important. There were entries made in the logbook, which was filed into evidence. There were reports filed at the police station and at the Coast Guard various authorities. All of those reports were important evidence. The captains of both the vessels actually testified in the proceedings. So you can actually see verbatim, it's translated, almost verbatim translations of the testimony of Captain Freddy, who's the captain of St. Anthony. So that's also on the record. So all of this was what the tribunal relied on to establish the facts. Now, as I said, there's no one standard set of how you prove facts. I'll give you one interesting story on this from a very old case called Corfu Channel case before the International Court of Justice. There, Albania was accused of having put some mines in the sea, and UK vessels had hit the mines and suffered damage. UK was before the court saying Albania is responsible. Now the court rejected the argument that Albania had laid the mines, but court was looking at whether Albania actually knew that the mines were there and had an obligation to warn the passing ships. So to ascertain whether Albania actually knew, what the court did is they appointed a person to go to the Albanian watch point near the sea on a moonless night, and they got a ship painted in black and got it to pass at the position where these vessels, the UK vessels, were passing. And the court was asking this person, can you see that ship on this moonless night from this place, or this painted black? And the person says yes. And the court says, because he says yes, under these circumstances, Albanian watchmen at this post should have been able to see the passing UK vessels and should have warned them. Now, that's a very exceptional and very, very rigorous way of ascertaining facts. And the court says they did that because a very serious allegation had been made against Albania, and a serious allegation requires a serious level of proof. But in this case, a lot of the facts were actually undisputed. Although India had initially maintained that the incident happened in the territorial sea, when you look at the parties' arguments in the arbitration, no one is disputing the place where this occurred. They're all saying it's 20.5 nautical miles. And the disputed facts are, was there a threat of collision between the vessels? Why did Enrica Lexie turn back? Was India forcing Enrica Lexie or tricking Enrica Lexie into turning back into India? Questions like that. And for that, the documents that I mentioned earlier was sufficient. Now, on the second question on whether, on the fact that there are pirates at sea and countries, vessels need to protect themselves from piracy, and what are their parts and how can they do it? Now, immunity, of course, means that only the country which, if it is a naval officer, if it's an official of the state, immunity means that it is the state which appointed this person, which has the action over this person. But at the end of the day, the question in criminal proceedings is whether a crime was committed, whether or not there was reasonable belief that this was a pirate attack, and shooting was justified as an act of self-defense or discharge of official duties under those circumstances. And that is for the Italian courts to decide, according to this award. So, yes, vessels and states still retain their right to defend themselves against piracy. There's actually an obligation to cooperate against piracy and to prevent and punish piracy. But there are also rules that require people engaged in the fight against piracy to distinguish between pirates and innocent targets. And that's essentially the rules of engagement in any situation where use of force is warranted. Even in war, you have those rules of distinction. And those rules exist, and that does not mean that states don't have a right to prevent or punish piracy or to fight against it.
Syam sir, please unmute.
Interestingly, with respect to piracy, we are in the process of drafting a marine piracy bill of 2019, and it's being considered now. And Mr. Deepak, interestingly, the fact is the definition of piracy that we are retaining in our 2019 bill, which might become an act in 2020, is the very same definition as we have it in UNCLOS. In spite of the fact that Aushile Loro incident and the SUA Convention and all those aspects have shown the world at large that the definition of piracy as we have it in UNCLOS, which mandates 2 vessels, is something so outmoded that the definition of piracy itself is redundant. And the better word to be used is unlawful activities against ships. And that is the whole way in which the SUA Convention was made. But still, we are making legislations based on this UNCLOS definition of piracy is something that's unfortunate.
Yeah, that's very informative. I look forward to seeing the draft of this legislation, and hopefully we can discuss this once I look.
The bill is already there, and they have started inviting public opinions on it. I think that it should be responded to massively by people who are interested in international law. They are present in the process of inviting public opinions.
Okay, I'll definitely take a look at that. Thank you.
Thank you.
So shall I request Shannu ma'am to, Shannu ma'am, thank you for waiting for so long. But please conclude the session by explaining us what really India should look forward and what are the takeaways from the discussions.
So good evening, and I'm really sorry, because I am speaking at the last moment, but I might differ with a few people on when we discuss on immunity issue. The reason is because one, that when you look at immunity under international law, as far as ILC draft articles on immunity of state officials from foreign criminal jurisdiction is concerned, the draft articles, plus the arrest warrant case, which was never overruled by the ILC's draft articles, it still restricts immunity in foreign criminal jurisdiction matters to Troika, which is heads of states, and not even to foreign minister. So in this case, I think we have gone overboard, to be frank. When it comes to PCA, it has actually gone overboard due to the international pressure to say that it can be applied to ordinary military people who are not even state officials, to be frank. Because even when you are extending military, you can grant diplomatic immunity only to diplomats who has the capacity to represent the state, not the ordinary military people. So the first and foremost, this is completely misplaced because it should have been under domestic local criminal jurisdiction. The matter should have been discussed in this forum. So hence India's concern that it was taken back from India's Supreme Court, and then of course there was some mismatch in India's concern because India had somewhere shaken it in between towards when the matter was discussed in Supreme Court. But despite all the shortcomings, I think this matter, when it comes to jurisdiction, was not relevant in this case because PCA does not have jurisdiction in this matter. The second is when it comes to immunity, it was wrong in judging that immunity can be granted because I must say that your PCA has created a wrong precedent by stating that you can extend to any ordinary military personnel. If that be the case, I'm afraid that tomorrow, our foreign heads of states would be tried like any other ordinary person in any other court, which I would not want to, because with all due respect, heads of states are representatives of the people per se. I think we should try to understand that where does al-Bashir of Sudan stand vis-a-vis to mariners in this case. So I think there is a clear distinction which was overlooked in this case. So arrest warrant case should have been referred rather than the history or precedents when it comes to citing customary international law itself. Second is when it comes to customary international law also, I believe that the state practice has a significant impact in changing the practices between states. So we all know that when it comes to formation of a custom and the distinction between custom and usage, custom need not be done for, let's say, 20 years, 30 years. Even if it has been practiced by two parties for, let's say, 5 years, it is accepted as a custom between parties. So hence, in this case, one of the important features is when you're looking at custom, even if you want to take customary practices, most of the states have actually gone beyond 12 nautical mile, and they have actually gone to 200 plus when it comes to exercising foreign criminal jurisdiction matter. And one more thing which I missed when I discussed immunities is that, even when you're looking at immunities, this has to be either multilateral level or bilaterally negotiated between parties. And unfortunately, India does not have any bilateral treaty with Italy when it comes to foreign criminal jurisdiction matters. So in this case, immunity was misplaced as far as the PCA is concerned. And I beg to differ because I think Alan Pillay was right. Professor Alan Pillay was really right when he argued that, on behalf of India, that immunity does not rest at all. Now, the plus point which has been cited by virtue of this award is that, we have won, which is actually not the case. Because I must beg to differ, because even when you're actually granting compensation to the parties, there is one more clause which says that you can actually, Italy has an obligation to go back and try the matter in their respective jurisdiction later. And we can bet that such a trial will never happen in Italy, because if they have been so protective of two mariners in Indian soil, definitely the matter will not be considered at all. The second is, of course, that is not our concern, but the fact is, when you're putting an obligation under the PCA's award, we have to be also aware of the fact that how much they have actually complied later, because it's like giving a remedy to the victims of the crime in this case. And secondly, when it comes to jurisdiction, let me just elaborate on jurisdiction part as well. Why does it become important to discuss at domestic local criminal jurisdiction, criminal courts, is because, of course, I'm a student of international law. With all due respect, I would always say that international law has supremacy, but barring full control on the state and its resources vesting with the state, which means state sovereignty shall not be hampered at any instance. In this case, when you look at foreign criminal jurisdiction, domestic criminal jurisdiction, we could have tried it along with, for example, when you look for Indian Penal Code, it should have been always read with the Foreigners Act 1946, because even for some time when they are in India, they are considered or Indian waters, because even if in this case they should have been considered as foreigners who are in Indian territory, even for some time, in which case when you're reading it with Indian Penal Code, it will give more strength in this manner. Now, again, the only hinge which is left is whether St. Anthony's has violated Article 87 and 90 of the UNCLOS. However, we all know that who has actually violated it. But on the other hand, the entire discussion is whether Article 87 and 90 has been violated by the St. Anthony's, which is actually misplaced in priority, because I think it should have been completely, that's exactly why, even in the judgment, even in the award, it clearly says that, it cannot be considered as valid, because when you look at Article 87 and 90, it has given some scope, at least to upholding law of the sea as an international convention, because it says that there was no violation. For a pure law student, international law student, that really has an implication, because when you look at Article 87 and 90, this was not violated by Indian boats is something which is really, really essential. Though I would say that it was passing the buck to the other side, saying that it was you who were guilty, not me. Now, again, the entire discussion about piracy is, again, when it comes to immunity also, let me come back to that point. Here you have commercial oil tanker. Now, that has been admitted even in the award that it's a commercial oil tanker. Now, the moment you say it is a commercial oil tanker, where does immunity come for such people who has blatantly violated human rights, criminal law of a country, and then human rights, fundamental rights, all the rights which you possibly discuss? So I think that in three angles, this judgment has gone as a wrong precedent in the jurisprudence of international law of the sea, because this has actually led to a lot of interpretation to say that we have succumbed to international pressures. Mind you, we should not forget that even before the International Court of Justice, when Marshall Islands raised issues regarding obligations or contestation on obligations towards nuclear arms disarmament, it was upheld against UK, not though against India and Pakistan, but against UK. So you can imagine a tiny country like Marshall Islands taking over UK and arguing that your right to nuclear arms is actually violating my right to survive in the world. Now, you can see that this was upheld in ICJ. So I'm sure that PCA would have been really pressurized to go make it Enrica Lexie rather than St. Anthony's and then go ahead with the case. So this is my observation, because when I quickly went through, I think there is nothing Indians can be happy about this judgment. And also as an international law student, this is something which has actually really hit us, because the basic traditional principles have been completely, even when you go by the changed customary practices, it was not adhering to the same. This is something which I believe, maybe I can be wrong, but this is my observation. Sorry to have made you, feel if I have gone overboard, but sometimes when we discuss international law, we have to be passionate, I guess. So, thank you, Nithin. So this is what I wanted to say, Nithin. So I don't want to take more time because it's already, people are waiting. But I'm open to questions. I don't have an issue.
Is there any response, or shall we close it? Thank you, Deepak sir, joining from abroad. Thank you, Syam sir, spending a lot of time with us. Shanuji, waiting for long and giving a personal narrative on the issue. We are so happy that we could get all three of you in this particular discussion, which really affects Kerala people. Many times we used to say when Hari sir and my other professors like Abhilash sir and Rohan sir come and meet, we used to say, many times the South Indian states do have a lot of concerns regarding international law, how it is articulated, how it has been present, and how do we get a necessary representation when the diplomacy happens at New Delhi. So thanks a lot for all of you joining us.